Thank you, Steve. My name is Andy Wilson. I'm the president of the OBA. Thank you so much for coming. This is part of the new OBA. All our CLEs are covered by our membership, and we are putting on some really good CLEs that you actually are going to learn something about. Today, we're going to have Professor John Lenich talk to us about our new rules of discovery and pleading. Professor Lenich is a graduate of the University of Illinois and Northwestern School of Law. After graduating from law school, he practiced in Los Angeles and specialized in antitrust and energy litigation. He then went to the University of Nebraska College of Law in 1984, and he taught for 36 years before he retired in 2019. He taught antitrust, appellate advocacy, federal courts, civil procedure, and remedies. He also served as coach of the college's national moot court team. He was a faculty advisor to the Nebraska Moot Court and was a special assistant to the vice chancellor for student affairs from 2017 to 2018. For many of you like me who attended Nebraska Law School, it was impossible not to have your paths crossed with Professor Lenich, and he was truly one of the good ones down there. Thank you for coming. Despite his retirement, John remains active in the bar. He is always working with our committees on new rules, publishing articles. He is of value to our practice in this state. He also serves on the as the hearing board chair for the UNL Office of Institutional Equity and Compliance. A little bit about John. John grew up on the south side of Chicago where he attended elementary and high school. He's a true South Sider. More than once, he may have skipped school to attend a White Sox game at Comiskey. Rumor is he's the one that suggested to Mike Veck that Disco Demolition Night would be a good idea. With that, I am very glad that John's here. Please welcome John Lenich.
Well, thank you, Andy. I'm glad to be here this afternoon to talk with you about the proposed changes to the Nebraska discovery and pleading rules. Now, the work on the proposed rules began in 2020 when the Supreme Court asked its Practice and Procedure Committee to review the discovery rules in light of the 1993 and 2015 amendments to the Federal Rules of Civil Procedure. Now, I don't think there was any particular problem or issue that prompted the court to act. I think it was more of just the court's sense that the rules, it was about time for them to visit the doctor's office for an annual checkup because they're not kids anymore. They turned 41 last month. The committee in turn formed a subcommittee to explore the rules and report back to the full committee, and the subcommittee decided to expand its project by taking a look at the pleading rules. Now, unlike the discovery rules, the pleading rules are kids. They just turned 21 last month. And perhaps because they are kids, we thought it might be a good idea to sit down and have a little chat with them because, as you all know, 21-year-olds don't always act responsibly. Now, the subcommittee submitted its reports to the full committee in 2022. The full committee completed its review in November of 2023 and submitted the proposed rules to the court in December. The court has decided to post the rules, which will for comment. They'll probably be doing that this week or next week, and there will be an extended comment period ending on May the 31st of 2014. Now, when you see the proposed rules, you'll notice there are a number of stylistic changes. Sometimes we followed the federal drafters, even though their language may involve things you don't particularly care for. For example, we followed their lead in using must instead of shall, but we did draw some lines. Whatever you may find in the federal rules, you will not find any split infinitives in the rules that we're proposing. Now, what I thought I'd do today is highlight what I think are some of the more significant substantive changes in the rules and answer any questions that you have. And please, as I'm going along, if you have questions or comments, please don't hesitate to let me know. I'd like to start with Rule 26 because that really is the keystone of the discovery rules. Everything really depends on what's in Rule 26. The current scope of discovery in Nebraska, as you know, is relevance. Folks can obtain discovery regarding any matter that's not privileged, which is relevant to the subject matter in the pending action, whether it's claims or defenses. If it's relevant, it is discoverable. Now, in 2015, those of you who practice in federal court know that the feds adjusted the standard for discovery and created two requirements. That in order for information to be discoverable, it has to first be relevant to the claims or defenses of the parties, and second, it has to be proportional to the needs of the case, considering at least the rule identifies a number of factors, such as the importance of the issues at stake in the action, the amount in controversy, the parties' relative access to relevant information, their resources, the importance of discovery in resolving the issues, and really the core of proportionality, whether the burden or expense of the proposed discovery outweighs its likely benefit. And as we thought about this, we opted not to include the proportionality requirement as part of Nebraska Rule 26B, primarily because we thought that the current standard, relevance, seems to be working well, and incorporating proportionality, we thought, might engender some more discovery disputes as parties explored how those various factors might affect the scope of discovery. Well, we thought that the core idea of proportionality, the idea of whether the burden or expense of the proposed discovery outweighs its likely benefit, we thought that was a sensible one, and also something that judges can and do consider in deciding whether to grant a protective order. And that's how we decided to incorporate proportionality into the rules. We created a new subpart in the provisions that govern protective orders, and that allows a court to deny or limit discovery if the discovery sought is unreasonably cumulative or duplicative, or can be obtained by some other source that's more convenient or less burdensome. Basically, you can get this in other ways, or you've had plenty of times to get this and you keep varying your requests and nothing is changing. Or again, that core idea, the expense or burden of the proposed discovery outweighs its likely benefit, considering the needs of the case, the amount in controversy, the parties' resources, the importance of the issues at stake in the action, and the need for discovery to resolve those issues. Now, I'd like to say that we came up with this all on our very own, but as you know the old saying, no lawyer has an original thought, and what we did is basically take this from the pre-2015 version of Federal Rule 26B2, but we put this into protective orders rather than using it as a freestanding section, and thought that was the better way of trying to deal with the issue, which is far less pronounced in state court than it is in federal court, of over-discovery. Now, one of the major changes that have been made to the federal rules over time, basically tracing back to 1993, are the disclosure requirements. In federal court, there are 3 sets of disclosure requirements. You got to provide information to the other side without any discovery requests. There are the initial disclosures, identify folks who are likely to have discoverable information that you may use to support your claims or defenses, documents by either a description of them, by category and location, or the documents themselves that you may use to support your claims or defenses. Plaintiffs, how about your damage computations? Provide that. Defendants, tell us about the insurance that may cover part or all of the insurance, or a part of the judgment that might be entered in the action. Beyond that, there are the expert witness disclosure requirements, and last but not least, the pretrial disclosures. And we thought about adding all 3 when we remembered that old saying that good things do come in threes. But then we remembered another good old saying, which is that sometimes you can have too much of a good thing, and we opted not to include initial disclosures or pretrial disclosures. Very few states have done that, but we did opt to include expert witness disclosures. And that, of course, raises the question of why did we single out expert witnesses for disclosure? And there were 3 reasons that prompted us to do that. The first is that the current rules, at least when you read the rules themselves, are pretty inefficient. They contemplate serving an interrogatory about expert witnesses, waiting for a response, or more likely a supplemental response, and then obtaining a stipulation or court order to take a deposition. Beyond that, we thought the rules are the system is a little disjointed, because yes, we have rules about the information that you can obtain from experts, but there's also case law out there. For example, there is State X Rel Acme Rug versus Likes, tells you about what kinds of information you can get from medical experts, but it doesn't tell you how to get that information. But the third factor is something that the cases do tell us, and that something is wrong here. Something's a little out of kilter, because the overwhelming majority of reported cases involving sanctions for discovery problems, they tend to involve expert witnesses. And we thought that providing some structure with deadlines might be of help to lawyers and judges alike. The proposed rule, Rule 26C1, would require parties to disclose the identity of its expert witnesses, folks who you're going to use to provide testimony under Rule 702, 703, and 705 of the evidence rules. And beyond that, it requires a signed report from experts who are retained or specially employed. Those are basically experts who learn the facts and form opinions for purposes of the litigation. For example, a plaintiff's lawyer retains a doctor to examine the plaintiff in a personal injury case, or the lawyer retains an architect to look over the plans for a allegedly defective building in a breach of contract case. So folks who learn about the facts and opinions that they're going to testify to for purposes of the litigation. And we base this primarily on Federal Rule 26A2, but we also took some ideas from the Nevada, Colorado, and Arizona rules. So what has to be in this report signed by the retained expert? Well, first, the opinions, the facts, and data that the expert considered in forming his or her opinions, and the exhibits that may be used to support or explain the expert's opinions. Beyond that, any identification of any of the learner treatises, the books covered by Rule 80318 of the evidence rules, any learner treatises that the expert may have relied upon, the qualifications of the expert, and any publications he or she has had over the past 10 years, with an option of just attaching the resume, or for the more highfalutin folks, the CVs, can attach that to the disclosure instead of spelling out all of that in the disclosure itself. Beyond that, what cases has the expert testified in as an expert over the past 4 years or provided evidence in? And that would include, for example, filing an affidavit in support of a motion for summary judgment. Beyond affidavits, the rule would also require disclosure of independent medical exams, which is required anyway today under the Supreme Court's decision in Likes. And last and not least, if we're talking about the specially retained experts, compensation. How much are you getting paid? And that can be satisfied by simply attaching the fee schedule. Now, because the expert signs the report, that means these are the expert's words, and the expert can be cross-examined on this report and is bound by that report. Now, experts who are specially retained aren't the only kinds of experts out there. There are also other types of experts, sometimes called actor experts. These are folks who learn about the facts and who formed opinions in the course of just doing their regular jobs. For example, the emergency room doctor who treats the plaintiff, or a police officer who investigates the accident, or an auto mechanic who repaired the car and made some recommendations about work that needed to be done a week before the accident. For these kinds of experts, there is not a requirement under the proposed rules of providing a report. Instead, there has to be a disclosure, basically the lawyer providing information, and that would include a summary of the testimony, a summary of the facts and opinions that the expert will testify to, a statement of the qualifications, and a statement of compensation. These folks may be compensated for the time they spend testifying, but since they didn't form their opinions for purposes of the litigation, they're very different in that respect from what we might call retained experts. But again, no report required for these folks, and primarily for two reasons. One is that oftentimes they're going to have contemporaneous documents that they generated in the course of doing their job. And two, they may not be as responsive to the lawyer as the retained expert, the one you hire. Just if you have a treating physician, they may not stop everything to call you back if you say, hey, I need some information about the case. Now, one of the lurking issues out there, this is primarily an issue in personal injury litigation, but it can rise in other types of cases, is what about the treating physician who testifies about causation? Does that cross the line from an actor expert into the retained or specially employed, the one who has to prepare and sign that report? And that's an issue on which the federal courts are kind of split down the middle. We talked about this and tried to decide what to do, and I could say we all agreed on the committee that we needed to have a rule. But there was disagreement about what the rule should say, and the view that prevailed was that a treating physician does not become a retained or specially employed expert. You don't cross the line if you testify about diagnosis, prognosis, or causation. But you do cross the line and have to prepare the report if you are if you go provide opinions, I should say, outside the course and scope of the treatment. In that case, then a report becomes required. Now, when do these disclosures and reports, when does the expert stuff have to be provided? In federal court, they say you have to provide these within 90 days before trial or when the case is ready for trial. But that's not really feasible in Nebraska State Court because oftentimes judges don't tell you in advance of a specific trial date or the like. And we thought about adding a requirement, basically adding some content to Pleading Rule 16 that would require the issuance of scheduling orders and the like, and we eventually opted not to do that, primarily thinking that's a matter best left to the trial judge. So what we ended up doing is tying the deadlines to the service of the first responsive pleading. The first answer that gets filed in the case, that's what's going to trigger the disclosure requirements. The expert disclosures have to be made within 180 days after that first responsive pleading is served, or if we're dealing with rebuttal evidence that's offered solely to contradict or rebut evidence on the same subject, then within 45 days after the other party's disclosure. And it again provides, though, the court can set a different date, the parties can agree to a different date, and that's necessary, maybe necessary in a number of cases. For example, if we have a bench trial in county court where there's going to be an expert witness, the case progression standards require that case to be moved along pretty quick, and 180 days after the service of the first responsive pleading in a bench trial might be a little late. Now, there is another question of, can you depose each other's experts? Do you need to get a court order? Do you need to get a stipulation? And the answer is no. You can depose the other side's expert, but there's a caveat. If a report is required, then you have to wait until after the report is provided in order to depose the expert. And the reason for that is that the report may help the attorney focus the deposition and just might, hope springs eternal, eliminate the need for that expert deposition. But that's basically what we decided how to approach expert discovery. And that, of course, then raises the question of everybody will comply, but what happens if somebody doesn't? And that raises the question of what are the sanctions? How does all of that work? Now, in federal court, the rules provide that you may not use information or witnesses that you failed to disclose, and this covers all three of those disclosure requirements, unless the failure to disclose was substantially justified or harmless. A few years ago, the Supreme Court in Nebraska here promulgated the rules for expedited civil actions, the County Court Expedited Civil Actions Act. And the court opted in those rules to basically leave the sanction at the discretion of the trial judge. One of the concerns with those cases, tend to be smaller cases, is there are quite a few disclosure requirements, and there was a concern there might be quite a few pro se, self-represented litigants in those cases, and having a less forgiving rule might not be the best approach. But we went back and forth about how to approach this, and we ended up deciding to incorporate the existing law into the rules. Now, Rule 37D of our current discovery rules governs sanctions for failing to respond to a discovery request or to appear for your deposition. It's the "they blew me off" rule. No objections, no response, no nothing. And the Supreme Court has held that sanctions can be imposed under Rule 37 when a party fails to supplement its discovery responses. And not surprisingly, most of those cases involve a party's failure to supplement the discovery responses about its expert witnesses. So what we did is we adjusted Rule 37D to say this rule applies, among other things, to the failure to appear at the deposition and the like. If a party fails to provide information or identify a witness as required by 26C, that's the expert disclosure provision, or by subpart E, that is the supplement provision, which has been adjusted to track the language of the current federal rule. And under the current rules, the at least the Supreme Court has provided that that you can preclude a party from using an expert witness under the rule. And so we specifically identified the sanctions that may be imposed for failing to supplement or to disclose. That includes prohibiting a party from using the information or the witness that they failed to provide when they were supposed to. And the beauty of this is the existing case law already identifies the factors. There's a whole body of case law out there that traces its roots back to the Supreme Court's 1987 decision in Noque versus Union Pacific that govern what the sanctions may be, what factors a court should consider in deciding whether or not to preclude a party from using a witness at trial. So what we essentially did is we changed the rules, but we kept the law intact. Now, whenever we're dealing with expert witnesses, one thing that sometimes may be a source of concern is what documents can you provide to that expert? If you provide, let's say, work product documents to the expert, have you now waived the work product protection? Are they fair game for discovery? Our current rules don't address that question. There is one Supreme Court case from about 14 years ago, Pedraza versus New Century Physicians, that kind of addresses the issue but leaves a number of key questions unanswered. And so what we decided to do is, our sense was there needs to be a rule so that you know what you can and cannot safely provide to the expert. And proposed Rule 26C4A and B, which are modeled on the federal rules, provide that draft reports, draft disclosures, communications between the lawyer and the expert, they are protected. They don't lose their work product status unless we're talking about communications regarding compensation or communications that identify facts, data, or assumptions that the lawyer provided and that the expert considered in forming his or her opinions. When we're dealing with documents and potentially privileged or protective documents, another kind of issue that's floating around out there is what happens if you inadvertently disclose a document. The lawyer, the eyes got a little bleary on the 10,000th document in the privilege review, and that big red privilege and confidential didn't wake you up and it slipped through. Currently, our statutes and our rules don't address the issue. Rule 511 of the evidence rules says that you waive the privilege if you just voluntarily disclose a substantial part of a privileged communication. What is intentional? Well, I don't believe our courts have, at least at the appellate level, decided that. But if we go to my all-purpose assistant, Webster's Online, at least involuntary or voluntary essentially means intentional. You knew what you were doing and you did it, but what happens if you didn't know? And that's the situation that proposed Rule 26B5 would address. That the disclosure of a privileged or protected document is not a waiver. We're not, and whether just either for the document or the subject matter, if the production was inadvertent, the party took reasonable steps to prevent the disclosure. That's really focusing on what was the process of privilege review that was done and were the procedures actually followed. And then lastly, did the party promptly take reasonable steps to rectify the mistake? Basically, get on the phone, send an email doing something, hey, give me that document back, destroy it, burn it, do something. Basically try to get the document back. And this provision is based on Federal Rule 502B of the Federal Rules of Evidence. The proposed rule goes a little further and addresses what the obligations a party has when it gets a document that it knows or should know is privileged or protected. Yes, that big red privilege and confidential got by the reviewing party, but the receiving party noticed that right away. Well, in that case, then once notified, the party who received what happens, what's supposed to be going on, once the party is notified that a document was inadvertently produced, you've got to return, sequester, which might be, hey, I'm going to put this aside, we'll argue about it in front of the judge, or destroy the document. You cannot use the document, and you need to take reasonable steps to retrieve the information that was disclosed prior to being notified. But what about on the other side, if you've got the document and you know or should know that it was inadvertently produced, then you have a duty to notify the other party. And that actually is our current duty. It's not in our discovery rules, it's in the rules of professional conduct, more specifically section 3504 4B. It talks about, at least the text of the rule, communications inadvertently sent. That's basically aimed at the emails, and many of us have those qualifications at the end of our emails. If you're not supposed to be getting this, delete this right away. But the comments to the rules of professional responsibility indicate that this duty isn't limited to emails. It extends to documents that are exchanged in discovery. And we thought that was worth including in the discovery rules because a lot of times folks may not make that connection between those two rules. I know for a number of years I didn't make those. But that's kind of an overview of the changes that are being proposed for Rule 26. And again, if any time you have questions or comments, please feel free to let me know. But as much as I'd like to know what we can get, there's the question of how do you get it? And what about the discovery mechanics? Because essentially we've got Rule 26, what you can get, some ancillary rules about where we can take deposition, who can be the deposition officer and the like. But the fun really starts with Rule 30, which governs depositions. And Rule 30, you would think, should be pretty much up to date because it was really substantially reworked in 2015 when we incorporated the provisions on interpreters. But that actually was what seems to be like a lifetime ago if we measure our lifetimes in terms of before and after COVID, because before COVID and today, the rules still provide that you can't just run off and do a Zoom deposition or the like, telephone deposition. You need a court order or a stipulation. And that fell by the wayside as a practical matter during the pandemic. And the committee believes that Zoom depositions are here to stay because they do eliminate the need for travel and that can reduce client costs and attorney hassles. I still remember years and years ago when I got to go on my first business trip and how exciting it was. But after the 10th trip, it got a little old in a hurry. And what the proposed rules provide is that unless the court orders otherwise, a deposition can be taken in person, by video conferencing, by telephone, or by a combination of these means. And what combination is aimed at is making it clear that there can be hybrid depositions with some folks participating in person and perhaps others by video conferencing. And what goes in the notice? Well, if we're doing a plain old-fashioned in-person deposition, then we need to state where that's going to be taking place. If the deposition will be taken by video conferencing, then the notice has to state the software and include the link, or state that the link will be provided within a reasonable time of the deposition. And our understanding is that's the prevailing practice out there. There are concerns sometimes about putting the link into the deposition notice, but we tried to provide some flexibility there. But if you have one party decides, I'd like to do a video conferencing deposition, and somebody else wants to attend in person, or vice versa. Somebody says, I'm going to do it in person. Somebody says, I want to attend by video conferencing. Then the proposed rules would allow the parties to do that. If you have, let's say, a deposition that's been noticed as in person, any party can notify the others that they want to attend by a different means. I want to be there by Zoom, and that has to be done within a reasonable time of the deposition. We figured people could handle that standard because right now, you have to give reasonable notice of the deposition, so we have at least a sense of the concept of reasonable notice. The rule, however, gives the court the ultimate authority here to control things, because it provides that the court has the power to, or at least the proposed rule gives the court the power to enter a protective order specifying the method of attendance. Because you can have weird situations. For example, the lawyer notices the plaintiff's deposition by video conferencing, and the defense lawyer says, I'm going to just show up at the plaintiff's house. I won't be inconvenient. I'll even bring, coffee and donuts. It'll all be okay. Well, you might not kind of like the idea of the other party being physically present with your client while you're not there. Maybe you decide to turn it into a in-person deposition, or maybe you seek a protective order from the court specifying who can actually be there. Now, when all of this is going on, where is the court reporter? Our rules currently provide that generally the court reporter has to be in the same location as the deponent. Now, by necessity, during the pandemic, court reporters and witnesses were not in the same location, and we're unaware of any major problems that engendered. Yes, you always have some concerns about coaching, or people looking at documents with their faces in the down somewhere. All you see is the top of their head, and you're thinking maybe they are reading from something. But what we decided to do is just eliminate that provision, but again, giving the court the power to enter a protective order if one needs to be done in any particular case. Now, there are some other twists and turns to the adjustments that we're proposing for Rule 30. Now, one of those is Rule 30 currently provides that a subpoena ducis tecum can be served on the deponent, and that a notice to a party can include a Rule 34 request for documents. Now, the response time for a subpoena is a bit shorter than the response time for a Rule 34 document production request. The document production request, that's generally a response time of 30 days, can you short circuit the 30-day period by serving a subpoena ducis tecum on a party deponent? And proposed Rule 30B2A would say, no, you can't, because the proposed rule makes it clear that the response time of Rule 34 will apply in that situation. There are some other twists. Depositions are fun, but interrogatories, they can be fun too. Sometimes they're not so fun. Currently our rules require a party who's responding to an interrogatory to reproduce the interrogatory and then underneath to state its response. That's a holdover from the old typewriter days, where you put typed up the interrogatory, then we left the space so that the other party's assistant could then type the answer on his or her typewriter, and away we go. Now, people don't, well, at least most people don't do it that way. I couldn't if I tried, because I gave away my portable typewriter about 10 years ago, but it's actually kind of convenient to have the interrogatory and the response to the interrogatory right next to each other. And that's really easy to do when the discovery requests are served by email in Word or WordPerfect, because you can just do an easy cut and paste. But what happens if somebody serves a PDF, which I still have not quite figured out how to edit, or worse yet, serves a hard copy by snail mail or by personal delivery? There, maybe you could scan it and all that stuff, but we thought that a better way of approaching that situation was to say that if you want we're going to require for document production requests for admissions, interrogatories, produce the interrogatory or request, then the response. And if you need a copy in the electronic format, all you have to do is ask the party that served you with the interrogatory or request. On demand, you're entitled to get it. We toyed a little bit with, well, why not just serve a USB drive or a CD-ROM with the request or the like? And the concern there was you may have cases with self-represented litigants, pro se litigants who aren't really going to use the electronic format. And while, yes, USB drives aren't all that expensive anymore, you serve enough of those and the cost can add up. But that's at least one of the changes that we're proposing. And we're also proposing some changes with responses to requests for admissions. And perhaps this is a good time as any to make sure people are following the rule. Now, let's assume I am served with a document production request, and I respond by sending an email on the 30th day to the party who sent the request to me, and I say, "Dear Smith, really had fun time with your request. Thanks so much. I have attached a zip file with all responsive documents. And you got any questions? Let me know. Have a good day. I'm going to go rest for a while." Have you complied with your obligations under the rule? Now, we got to know, do we have a yes? Anybody yes? Who says that is a rule follower rather than, why is that a violation of the rules? I'm sorry, I don't remember. Rich, why is that a clear violation of the rules just to send off the documents?
Yeah.
It's like a law school.
I think you have to answer the request one by one.
Yeah, that's what our rules provide. Just giving them the documents. You have to provide a response, and Rich is right here, and state that inspection and related activities will be permitted as requested unless you're objecting to it, in which case you got to state your objection. But just giving them the documents is a clear violation of the rules. Now, that's what a lot of us do, and it makes a lot of sense. So the proposed rule would change would change things a little bit and say, yes, you can respond to the request. And that was all aimed at the good old days when you put the documents in the banker's box and put them in the office or at a warehouse and say, come look them over, see what you want to copy. Alternatively, you can state that you're going to produce a copy of the documents or the electronically stored information, and if you just produce it and say, here it is, then you are actually stating you're going to produce copies. I thought it was best to have the rule correspond to what a lot of people do in practice. Because again, I'm not aware that a lot of people are out there still remembering what it was like to go to the warehouses and the like. But that's at least one of the changes in Rule 34. Now, in and this was a change that actually the feds made in 2015 in the 2015 amendments. Now, what about objections? Both Rule 33 and 34 currently state that a party must state the reason for the objections it makes. And that language was taken from the language of the federal rules that was in effect in 1983 when our rules were first adopted, became effective, I should say. Traces its roots back to the 1970 version of the federal rules. And the federal rules were this is what's in our current rules, I should say, and you have to state the grounds. And then what about explaining them? And the federal rules were amended in 1983 to require the objecting party to state its objections with specificity. And the purpose of that was to eliminate the so-called boilerplate objections, the ones that state in a very polished, sophisticated, and professional way that your interrogatories really suck. Blank objects to interrogatory number blank on the grounds that it is vague, ambiguous, overbroad, and oppressive, and imposes upon blank the unreasonable burden of defining its breadth and scope. Blank further objects to interrogatory number blank, and on it goes, and it sounds really good, but what's the problem? Just tell me. And what at least we said was we can see some advantages and disadvantages to requiring objections to be stated with specificity as the federal rules do. The advantages are that it could discourage boilerplate objections, can discourage baseless objections, and maybe help the parties resolve discovery disputes informally, because at least you know what the beef is. But there are some disadvantages. They're going to require a little more time, and they may engender some disputes over the sufficiency of the parties' objections. But the committee thought that on balance, the advantages outweighed the disadvantages, but we struggled with the phrasing. What does it mean to say you've got to state your objections with specificity? And we thought that we ought to just say what that means, which is that you need to state the grounds for the objection and explain with specificity why the interrogatory or request is objectionable on those grounds. And that requirement would apply to both interrogatories and document production requests. But what happens if you don't make your objection? And our rules currently don't say what happens, but at least the federal rules provide that you waive your right to an objection unless the court finds that there was good cause for your failure. And we thought that's a sensible approach, and from what we could gather, that's what judges generally do, that they will excuse the failure to make the objection if there was good cause for that. And it also makes some sense, because treating the failure to make a timely objection as a waiver, that encourages folks to take deadlines seriously. But at the same time, recognizing a good cause exception allows courts to examine the circumstances of the particular case. There may be good reasons why it happened. Somebody's grandchildren got sick, they were in the hospital, or something else happened at the office, or it got overlooked, but we're on top of it now, and we've been really good in discovery in this case. Plus, there are not all objections are created equal. An objection on relevance grounds, waiving that isn't quite as serious as waiving an objection to based on the attorney-client privilege. Now, sometimes what happens is that people will make an objection. I object to this document production request on the grounds da-da-da-da-da, but subject to the foregoing, see folder C. Okay, so you're looking in folder C, and the question you're wondering is, did I get everything, or are they giving me some of what's being withheld? We've heard some horror stories about that, and therefore decided to follow the federal lead and say, if you're going to object to a document production request but still provide some responsive documents, then you need to make it clear whether you're withholding any documents on the basis of that objection. Now, there is another question that we discussed about what needs to be stated in terms of the objection, or when you withhold documents on the basis of a privilege or a protection. And the federal rules address that issue, and we decided to follow suit. They address it, and if you withhold the information otherwise discoverable by claiming it's privileged or protected by the work product protection, you've got to expressly make the claim, and you also have to describe the documents and communications in a manner that will allow the other side to assess the claim. We talked about, should we have a more specific requirement? Basically following what the current rule is in Nebraska under the Supreme Court's decision in Greenwald, where you've got to provide lots of detail about every document that you're withholding. And we opted not to do that on the ground that sometimes providing document-specific information, and that could be a real pain. It could be unduly burdensome in cases with large numbers of documents. So we thought the better approach was to keep it a little less specific here. And again, court can order otherwise, but at least we've got to say something. We've got to make the claim expressly and provide some indication or enough information here so the other party can figure out why we're withholding that information. It wouldn't be a talk about discovery if we didn't talk a little bit about motions to compel and what the requirements are. Currently, a number of our districts here in Nebraska have local rules requiring that the parties make a good faith effort to confer and resolve the dispute before filing a motion to compel. My understanding is that's true here in the 4th district, and that's true in about 5 other districts. And as we thought about that, we said, that makes a lot of sense. Plus, we've already reached critical mass. Got 6 districts. Another district had a rule under consideration when we began this project. So we thought that should just become a statewide requirement. And we also included this requirement of meeting and confer in the provisions governing protective orders, and a variation appears in the deposition rules on entity depositions. Rule 30b-6, where the party has to confer with the organization either before or shortly after serving the notice or the subpoena, so that and try and make sure everybody's clear on what the subjects of the deposition are going to be. Now, where does the motion to compel, where does that have to be filed? Well, under the proposed rules, they're all going to have to be filed in the district where the action is pending. And that's true even if the motion involves a matter relating to a deposition. Rule 37A currently gives a party the option of moving in the court where the action is pending, or in the district court for the district where the deposition is being taken place. And it also provides that if the opponent's a non-party, then the motion can be filed in the district court of the district where the deposition is being taken. We've tried to eliminate all of those twists and turns because our sense is the judge who's handling the case, judge before whom the action is pending, is in a better position to rule on discovery issues than a judge who's unfamiliar with the case. Plus, today's technology makes it a little easier to get a remote ruling than in the old days. And under the circumstances, not always clear what the most convenient court is, or where, for example, the deposition is being taken. If we've got a witness or deponent who lives in Saline is being deposed in Lancaster, the lawyers are in Douglas and Washington counties. I mean, kind of where is that deposition being taken place? And we also eliminate the options of filing elsewhere for motions for a protective order or to compel compliance with subpoena. Basic idea is to promote consistency and eliminate the need to trigger or turn on somebody's GPS. The last subject I'll mention on discovery is electronically stored information and the potential destruction of that stuff. Sometimes there's no point in filing a motion to compel because what you're trying to get is no longer there. And if it's no longer there because of spoliation, that can present some problems. Now, there are no Nebraska reported cases, I should say, on this issue. But the committee feels that sooner or later it's going to come up. Somebody's going to trade in their phone and fail to preserve all the text messages, or somebody's going to wipe their laptop clean or get a new laptop or allow data to be overwritten, and that triggers issues of spoliation. Our current law is case law. From State versus Dablin, a case that involved the destruction of a larynx in connection with an autopsy, and the Supreme Court said sanctions are appropriate if the evidence existed but was subsequently destroyed. The party responsible for destroying it had possession or control of it. The party destroyed the evidence intentionally and in bad faith, and the evidence would have been admissible at trial if it had been destroyed. And the court talked about possible sanctions, which would include drawing inferences that the destroyed evidence was favorable to the other party, or giving adverse instructions in jury trials, which is a scary thing, because that's basically going to end the litigation. The subcommittee and the committee both thought it would be good to have a rule to provide some guidance, because this can be a scary area, especially given that the sanctions can be severe. And what we thought was best was to follow Federal Rule 38E and to incorporate that into our rules. And we did that in large part because we thought the federal rule kind of corresponds pretty closely with our current law. Two, if we would have the advantage of a substantial body of federal case law that judges and lawyers could rely on. And three, we think it's kind of a sensible approach. And it goes in multiple stages. The first question is, did we have a failure to preserve electronically stored information? The stuff got destroyed, even though a preservation letter had been sent, or there was clearly foreseeable litigation. 4 people died in the car accident. Litigation is going to be coming in that situation, or we actually have the litigation having been filed. The stuff should have been preserved. It was lost because the party failed to take reasonable steps to preserve it. No backup was attempted. It wasn't simply a case of documents magically disappearing, failed to take reasonable steps, and you cannot restore or replace it through additional discovery. Because sometimes you can get the stuff from maybe non-parties. The party erased all of its communications with X. Well, X may have those emails in its files. But if we're in a situation where those requirements are met, then the first question is there prejudice? And if there isn't, well, then we're done. But if there is prejudice, if the destruction impeded the party's ability to prepare its case, then the court may order measures no greater than necessary to cure the prejudice. For example, might have a situation where some of the records and employee performance records were lost. They were deleted. They should have been preserved. Under the best evidence rule, the employer can have the the HR person testify, well, here's what was in all the reports, really bad employee. But a court might say, no, this stuff was lost because of what you did, no testimony from your people about what was in those reports. But what happens if you have a situation where the party acted with the intent to deprive the other party of the information? You acted in bad faith. Maybe all the contemporaneous reports of the accident got deleted. And that was all done pursuant to the company's normal document retention policy. So far, so good. But that was all done 3 months after the lawsuit was filed, after preservation letters were sent, identifying the electronic documents or types. And nothing got preserved, no litigation holds got issued. Boy, the line sometimes between negligence and bad faith can get pretty slippery. But on balance, I think these are, the sense was, this would be of some help to the issues we know they got to be percolating out there, and it would be helpful to have some rules. Now, there are some twists and turns to the pleading rules, but I think we've had enough civil procedure for the time. We're getting our credit for today, and at least on the discovery, I hope that you've liked the proposals that you heard about. I know there are lots and lots of changes here, and I'll swip through. Why won't this up? Because I'm not hitting the right one. There are quite a few changes, and we'll even let that one go. Lots of stuff. And you're saying, my God, there's a lot. But I think these changes are changes for the better. And if you have comments, when these rules come out, there'll be some reading to go with it. I think the reports run about 150 pages. So, but please submit your comments to the Supreme Court, especially if you're going to comment, these are the greatest rules we've ever seen. Get those in very early. And with that, I appreciate being invited and having the opportunity to talk with you and this afternoon, and be glad to answer any questions or take any comments that you might have. But thank you very much.